unstoppable special needs estate plan. We're going to talk about what a special needs trust is and what you need to do to create that comprehensive special needs associated estate plan. We're going to talk about new critical California property tax laws that have huge implications. We're going to talk about updated ABLE Act rules. There's an update in California ABLE Act accounts that think you should know about. We're going to talk about how the ABLE Act fits in to an overall estate plan, a special needs estate plan. Do you have enough? Now, let's think about what amount of money is going to be needed to support your child after you're gone. And let's think about how can we be sure that you have enough and that gap is filled. And then we're going to talk about some specific steps you can take. And this is the book Mike and I authored, Special Needs Trust Creation and Management Guide. It is available on Amazon. And if you're a client of our firm, we'll give you a copy when we start working with you as well. What is a special needs trust and how does it fit in with my estate plan? A diagnosis changes everything. Think back to that day, if you have a child with a disability where you got the news that your child was going to have some challenges and that your family was going to have some challenges.
The bottom line, one of the most important or the best known benefits of a special needs trust is that any amount of money, any resource can be in a properly drafted special needs trust, and none of it counts. None of it interferes with eligibility for any of the needs-based government programs. There's supplemental security income, SSI, which guarantees a monthly income. There's Medi-Cal, which is California's version of the federal Medicaid program. There are housing subsidies. There are some programs that are for everybody with a disability. There are some programs that really depend on some eligibility criteria that are financial. But it's a job to be the trustee. We spend a lot of time talking about that. It's our job to know about the resources in the community. Mark is on the board of directors of one of the autism organizations here in our community. For example, we've helped many, we serve with many. It's part of the whole. And importantly, when we draft these things properly, upon your child's passing, there's no payback to the state of California. All the money goes to your family members, to the nonprofit organization that might have assisted you.
Yeah, a simple illustration, I think this is important. So I think there's some confusion and misconception about do I create the special needs trust and I put all my assets in it? And when does it get set up? When does it get money? It's actually fairly straightforward. So you need, say mom and dad have a daughter, Sarah, with special needs. She's going to need support and need government benefits. Mom and dad would set up their own separate living trust. Everybody over the age of 18 really should have a living trust. It's a way to leave your assets where you want without getting stuck in the courts. There's a lot more we can do with that. So the key here is you do not leave money directly to Sarah. Instead, you leave it to the special needs trust that's created for Sarah. And the trust is there to support her for the rest of her life. A third-party trustee is in charge of it, and it doesn't interfere with government benefits, and it can really be used to make sure that Sarah is okay. So it's really that simple. And if you have other kids, we'd recommend different trusts for your other kids, or you can leave money directly to your other kids.
Money in the special needs trust is there for the quality of life of your child with a disability. It's there to pay for anything that some form of government benefits does not pay for. So are there any limitations? What can it be used for? It is so broad. There is so much flexibility and discretion for the trustee. I mean, the trust language has to give the trustee that flexibility and that degree of control. And if properly drafted, they really have it. It's not limiting, very comprehensive in terms of the flexibility. Automobile, entertainment, and by the way, what about concert tickets? What about plays? Things like that. Mark, any insights here?
Funny you ask, Mike. So believe it or not, there's actually a case about this where special needs trust assets can be used to pay for Britney Spears concert tickets. Yes, Britney Spears, of all things, there's actually a court case about that from 2004, where a trustee was challenged for daring to use special needs trust funds to take a big Britney Spears fans to go see one of her shows. So the point here is the funds in a special needs trust, it's not like they're super strictly limited. There's flexibility. A lot of our clients, they think like, well, my kid might be doing okay in the future. They might not need public benefits. They might be able to support themselves. Maybe I don't need the special needs trust. When in doubt, put the special needs trust in place, because if they're thriving and doing well, the trust is flexible. It can support them in so many ways. But if they need those government benefits, then it's absolutely crucial that it be a special needs trust. Not to mention the fact that it can protect them from bad third parties who might try to steal their money.
If there are other kids, we would recommend these Dynasty trusts because they're so incredibly important and powerful. So the concept is leaving assets in trust for the benefit of your children to protect the money and to protect your kids. So many issues have to be addressed. It depends so much on whether a family member will be a trustee or a professional will be the trustee. There might be accounting responsibilities built in. Sometimes the nature of the disability compels us to include certain language because we know there's certain issues that are going to come up. Individualizing the planning, being sensitive to what is actually going on in the family, including the size of the estate, the nature of the assets in the estate, it ought to be coordinated. And we work really hard to integrate all of those pieces to be sure we come up with the best plan for everybody.
You need sophisticated, durable powers of attorney for you, mom and dad, so it can allow, if you're incapacitated, to step in and take care of your child. And as Mike said, we want to integrate everything. We need to make sure it all fits together. If you have a child with special needs, and you want to leave property to them, you need to be aware of the impact of Prop 19 on California property taxes. This can be a massive issue for all families, but especially if you hope to leave your house or a rental property to support your child with special needs in the future.
What affects us more deeply than the worry that our child might not have a safe place to live? It may be mental illness and your child may, God forbid, be on the streets. If your child needs a great deal of support, will there be an adequate housing environment for him or for her? We guarantee you that the supply of high quality group homes in the future is not going to be adequate. It's not adequate now, and it's only getting worse. And the supply is not keeping up. In part, it's the cost of land and housing in the Bay Area here. It's just devastating.
Or anywhere in California, by the way. Southern California, anywhere.
So many of us plan on retaining the home, our family home, and having it there for our child. Your home may be your child's home, the only home he's ever known, and it is the future. Even if there has to be somebody living with them someday, that's going to be comfort. That's not a break in continuity. What if you want to save the home for your kid and you're not aware of Proposition 19, this dramatic change that undercuts the legacy of Proposition 13. Prop 13 in the 70s rolled back property taxes to a very low level, and they increased 2% per year. We have Prop 58, which said that when you pass your residence along to your child, whether or not your child lives in it, no property tax increase. Prop 19, this new law, destroys all of that. Drink that in. Okay, there's going to be massive reassessments on property when you pass away and the property goes to your child. It's a change in title, so you can't get around this by simply transferring your home to your child right now. That would accelerate the tax increase. So
yes, do not do that.
We have to look at this carefully and comprehensively. So let's take a simple example to play this out. Here we have somebody where the property taxes were minimal in the past.
$4,000 a year, let's say.
$4,000 a year.
Slide says.
Okay. We see this all the time. You bought your home so long ago and the price was so low, prices kids can't even imagine today, and the property taxes are very, very low. And now let's say that the market value is $3 million. If your child receives the home and doesn't live in it, the property taxes are completely reassessed. Property taxes go from $4,000 to like $34,000 per year. So this is $1 million over your child's lifetime. It's dramatic. The exception, if you have a child who makes your residence her residence, then the first $1 million in reassessment is forgiven. It's not completely protected, notwithstanding articles that we saw in the San Jose Mercury and other publications. It's a partial protection. If that's the case, the first $1 million is forgiven, so the new assessed value is going to be $2 million. Property taxes go from $4,000 up to about $23,000. And you got to be really careful to capture that benefit, by the way.
Yeah, and no exemptions for a child with special needs, by the way. So Mike, why don't we talk about rental properties and the fact that there are now zero protections, right?
So now you have a rental property, you have a vacation home. We have a number of clients who purchased duplexes. The idea being that their child will live in one of the units and a caregiver is going to live in the other. And they've had it for a number of years. Here we go. Property taxes are low. So let's go to another hypothetical where the property taxes are about $3,500 a year and the market value is 2.8. You pass away, the property goes into the special needs trust for your child, and you think that's a perfect solution. To an extent it is, because your child has a place to live. What happens with the property taxes? They're going to go from $3,500 a year up to about $30,000 a year, no exceptions.
One is if you work with us, we have solutions, by the way, but yes.
If you have real property and there's any thought about keeping that property in the family for your kids, and let's face it, real property in this area has been gold. It's been one of the best investments you could have. Now, if your child is going to sell the house for sure, you don't worry about it, but that's rarely the case. At least a smart kid wants the option, keep the property in the family if he or she wants to at low property taxes, or sell it. And of course, if we structure it properly, no capital gains tax.
Let's say that a home is worth 3.3 million. And I know that's a huge number. I get that. But you leave it to a special needs trust and your child with special needs lives in the house. If the assessed value is $300,000 today, when you pass away or when that goes to the special needs trust, property taxes, even if your child's living there, would go up from about $3,300 a year to over $25,000 a year. Now, what does that mean? Over 5 years, that's $114,000. Over 10 years, $240,000. If that house is there for your child for the rest of their life, 30 years or more, about almost $900,000 in extra taxes that have to be paid. And you get nothing for it. And keep in mind, this is after-tax money. You can only deduct a little bit of property taxes, a small portion of property taxes from your income tax. So to pay those extra $890,000, the special needs trust would have to earn an extra 1.3 million or so. If you don't fix this problem, and we can fix it, that's why we're talking about this. We wouldn't just talk about a problem, we didn't have a solution. But this will often force the sale of a property, and keep in mind, if you structure it properly, you'll get a stepped up basis, or your child will, so they can sell a property with no capital gains taxes, but they need somewhere to live. So if you buy another property, even if it's cheaper, the property taxes are probably going to be a lot higher than if we just locked in the low property taxes for what you already have.
If we're dealing with Prop 19 and taking steps to preserve property taxes, we have to look at whether or not there's exposure to the estate tax. The level of protection is extremely high, but in a couple of years, it's going to go down to a very high level, but half of what it is today. In some situations, it's important, if not necessary, to capture this thing called the stepped up basis, which simply means that after mom and dad pass away, the property could be sold and there's no capital gains tax. Sometimes, for estate tax planning reasons, we give that up. Think about the amount of money, cash, that would have to be in the trust to service the property tax. While there's a need for that money to pay for health care, to pay for Britney Spears tickets, to pay for transportation, there needs to be a lot of money in the trust. Ideally, you don't want that money wasted on a massive expenditure that's avoidable.
What is the ABLE Act?
So this is another planning opportunity that is often coordinated with special needs trust planning. So if you have a child or another loved one with a disability, money can be deposited in an ABLE Act account. We call it CalABLE here in California. Up to $17,000, the annual exclusion amount. That amount of money can go into this account. It can build up to $100,000. None of it interferes with eligibility for SSI, the income program that's guaranteed through the federal government. The money can be used very, very flexibly. It is tax benefited like a 529 plan. If there's growth, there's no tax on any dividends or interest that might be generated. The state of California gets no payback whatsoever. So the money passes along where you would want it to go. We usually recommend that you don't establish a massive account for a combination of reasons. It's a viable alternative to supplement the planning that otherwise goes on. So it's not a substitute by any means for a special needs trust. It's an element of the overall plan. Coordinating everything is the key.
An ABLE Act account is great in many situations. We often recommend it to our clients.
Your child may be disabled, meaning that he or she can't work, but they may be able to manage money, or at least small amounts of money. So your child can be the manager and be in control of this account.
They cannot be in charge of their own special needs trust, which needs to be where the majority of assets are. So good thing to set it up in California, don't set it up in another state. How can you be sure that there's enough to support your child after you're gone? This is something that keeps people up at night very understandably. It's absolutely crucial to leave money for the benefit of your child to their special needs trust.
Most of us don't have enough money to do this, but this is a question of what are the projections? If you make certain assumptions about the cost of living, about housing and healthcare and so on and so forth, what could be spent to support your child for the rest of his or her life after you pass? And it could be $3.5 million. Okay, not practical for so many. So you do what you can. Is everything going to be left to the child with a disability? The resources are not increasing for housing in particular for individuals with disabilities. That's our major concern. The demand for supportive services is off the charts. We're not fans of life insurance in every context, but here it can make a great deal of sense. And I want to tell you the shortest story, a very real story about a family I worked with a number of years ago. They had 2 kids. They were in their 40s. One child profoundly disabled, and they were utterly worried, consumed with worry about how that child was going to get by. They didn't really have much money. Importantly, they brought mom's mother and father came along to that meeting just to be there and be supportive. So we talked about life insurance. We referred them to the life insurance professional with whom they worked. They qualified for life insurance. And here's what they did. They looked at what's called the second to die life insurance policy. It doesn't pay off until the second death for $1 million to fund the special needs trust. They looked at a number of alternatives in terms of how they could fund it. They could pay annually. The premiums would be about $4,300 a year going forward, or they could pay about $60,000 once. Mom and dad heard that. Over time, they chipped in, they bought that policy. And what was so amazing about that is after the policy was purchased, mom called me up. She was weeping and she said, that life insurance policy, this sounds silly, but because of that, for the first time, we felt, number one, that we could now leave a portion of the estate for our other child. We were going to leave him nothing. Number two, for the first time, just this feeling of liberation, we felt we could take a night off. This child was 2 years old. They didn't take a break. They went crazy. They went to Carmel overnight where the grandparents took care of the child. And again, stimulated by a life insurance policy. It's symbolic as well as very real in terms of money.
We find this from other advisors in this field. I think life insurance is a nice way to bridge some of that gap. And if you have an old life insurance policy, you might be able to trade it in for a much better new one. Talk to us. We can connect you with people who can help. So, to decide how much life insurance you might need to figure out your plan, we kind of developed a framework for thinking about that. The more, the better, right? Like if you have $100 million, hey, leave whatever you think is absolutely enough for your child and then some. No downside to having too much, because again, a third-party trustee will oversee it for your child. But I like to think about this as retirement, right? Because when you retire, in theory, you're not going to be earning any new income. Good rule of thumb is the 4% rule. You should be able to rely on a 4% return every year. And in theory, the principal, the amount you have invested in the bank, should generally stay at where it started. So it should be something you can do forever. So in simple terms, let's say you have $1 million put away for your retirement. It's invested reasonably well. In theory, you should be able to take out 4%, $40,000 a year for the rest of your life. And that $1 million might go up, some years might go down, but it should stay at about $1 million. Historically speaking, that's been reliable. Similar for special needs planning. So as a parent, think about how much your child will need every month. Right? If you're gone, let's say, hopefully they get SSI, maybe they get Medi-Cal, that'll pay some of the costs. But what is that gap? Are they going to need caregivers? Are they going to need to go on trips? Come up with a rough budget in your mind, factor in some inflation as we've had in the last few years, and maybe say, if my kid has $10,000 a month, that's a big number. But if they have $10,000 a month, that'll be plenty. We need to think about other resources as well and how they need to be coordinated. So one thing that's absolutely crucial, if you have a retirement account, you would leave your retirement accounts to the special needs trust as well. And there's a new law called the Secure Act that passed just a few years ago. And if you leave your retirement account to a child without a disability, they have to withdraw that money within 10 years. And they have to pay taxes every time they withdraw it. If it's to a special needs trust or an individual with a disability, it can be spread out over their lifetime. So very, very important to update the beneficiary designation of your retirement accounts and to make sure that's all coordinated. This is kind of one of the secrets to an unstoppable special needs plan is having the right team. So that involves having an integrated legal and financial team, maybe an insurance advisor as well.
The countless occasions where the right hand, legal planning, doesn't get communication from the left hand doing the financial planning. And we see very inappropriate investments being made, sometimes annuities that make no sense for somebody who's in their 80s. So we're now developing this team and making sure that the financial advisor professionals understand these issues, understand how it all fits together, integrating it, making sure that it's coordinated.
We're piloting a new program around this where we are forming a partnership with a couple financial advisors who do specialize and really work with families in this area. So we want to integrate insurance planning, financial planning. We're starting to build that called the Gulfix Family Office Program. We haven't finalized it yet. If you're interested in having that, There's no really extra cost to families who take part. The first thing we start with is not the special needs trust. It's your plan, right?
Right. It just has to be comprehensive. It has to be coordinated. If you haven't looked at it or had us look at it over the last couple of years, check in, make sure that it makes sense. Make sure you have your revocable living trust, powers of attorney, advance directives. These documents should be prepared for the benefits of your adult children as well. You don't have to be a mega billionaire to benefit from Dynasty trusts. They're for everybody because they're so incredibly protective. If you do have a child with a disability, are the planning steps taken by the grandparents and the aunts and the uncles coordinated with you? They need to integrate planning for the special needs trust for your child into their estate plan. The annual exclusion, that's the amount of money you can give away every year without having to report it to the IRS. If you are potentially exposed to the estate tax, you should be doing that and taking many other steps.
Overcome the 3Ds, the danger of delay and denial. It's a version Mike came with before. Don't be the ostrich with your head in the sand. Special needs planning in particular, you can't wait. You have to take a fresh look, make sure it's up to date. Your family's going to be spending a lot more money later, or your child's going to lose benefits, or they're going to face unnecessary taxes. So spending a little bit now on having that legal and financial team and having good advice can pay off many times over, especially in the special needs planning space. Like this, comment, leave us questions. If we didn't get to it, try to leave it in the YouTube channel. We'll try to get to some of those. We would love to be part of your team. We think it should be integrated with your financial and insurance plan. Reach out, contact us, 650-493-8070, gilfix.com. Very easy to find us. We're all over the internet.